All right, sir, is your name David Maynard?
Yes.
Mr. Thompson, are you good?
Yes, Your Honor. Jason Thompson, duty attorney.
Okay, Ms. Chady, you're appearing on behalf of the people today.
Yes, Your Honor. Dana Chady on behalf of the people.
Okay, this is People versus David Robert Maynard, District Court file number 2417682. I'm conducting this arraignment on behalf of Judge Burmeister today. Mr. Maynard, you're before the court today for arraignment on a 2-count felony complaint. Do you understand why you're before the court today?
I think, I mean, I heard the complaint. Yeah. Yeah.
All right, I'm just going to make sure that you're aware of what the charges are. You're charged at count 1 with possession of methamphetamine in that on or about October 10th, 2024. You did knowingly or intentionally possess methamphetamine. At count 2, you're charged with operating a motor vehicle without security as required by statute. Do you understand the charges?
Yes.
Mr. Thompson, have you had a chance to speak with Mr. Maynard today?
I had, Your Honor. We did review the complaint and maximum penalties that were needed for the reading. He would stand mute to the charge as an activity to be entered. He did request court appointment, so I did screen him. He qualifies. I will be appointed. We will waive the review for purposes of preliminary examination. Our request for cash bond. Thank you.
Thank you. The court will enter not guilty plea on behalf of Mr. Maynard with regard to both charges in this case. The court will set this for felony pretrial on November 26th at 1 p.m. and a preliminary exam on December 3rd at 2 p.m. Mr. Maynard, you'll be provided written notice of those hearing dates. So your next date in court after today will be on November 26th. In terms of bond pending that hearing, Ms. Chady, do the people have any recommendations?
The people would be asking for a low cash, a cash bond. We would defer to the court on the amount based on the seriousness of the charge of the added felony. Thank you.
And Your Honor, my understanding is Mr. Maynard does not have any prior felonies. He's not out of probation. Traffic misdemeanors. He advises as his parents tell us as to that community. He's asking to consider.
All right, I think that's a reasonable bond. The court will set bond at $10,000, 10% cash or surety. And all standard conditions of bond. Ms. Chady, anything further we need to address for the record today on behalf of the people?
No, Your Honor, not on this matter. Thank you.
Mr. Thompson, anything further on behalf of Mr. Maynard?
Nothing further.
Mr. Maynard, do you have any questions at all?
So the bond is what I couldn't hear all of that part, I guess.
It's set at $10,000, 10%.
Okay.
Did you have any other questions?
No, I guess not. I just have to try and get back to my parents. They're elderly and I'm the one who lives with them. So that's what I'm going to try and do.
Okay.
Your Honor, one last clarification. Mr. Maynard advises the proper street address is 128 East Bay Street. So I'd ask that the court file reflect that. Thank you.
Okay. Thank you. That's all for today. The court's going to disconnect from the jail at this time.
Okay.
Thank you.
And then Mr. Thompson, you just can stay right here.
That's
Mr. Leonardson, are you able to hear me okay?
Yes, I can, Your Honor.
Okay, we'll go on the record. This is Coppermell versus Patrio, case number 2311369. The record should reflect that Mr. Thompson is here on behalf of plaintiff. Mr. Thompson was attending a different hearing, so he's here in the courtroom. We have all other counsel and parties present by Zoom video today. This is set for a motion. Mr. Thompson, I had a chance to review your motion. Mr. Leonardson, I did get the brief that you filed on October 28th. I've had a chance to review both of those. Mr. Thompson.
Two things here. Karen, I don't show receipt of the 1028 response. Filed it, maybe the mail 1028. See what I have.
Mr. Did you send your documents that you filed on the 28th of October to Mr. Thompson? I don't see a proof of service in the file.
I did send a copy to him, but the motion is somewhat moot on the basis of actions of my client. It would, it still is in a request, but it would be modified. She has, since my motion or during the process of my motion, because she could not get Ms. Copernall to sign a quitclaim deed to maintain the mortgage, she filed for a new mortgage, and it's been approved and is ready to close on that with the same terms and conditions. It would require a quitclaim deed, and she would be, in return for that quitclaim deed, would issue a certified check for $11,000. But Ms. Copernall has continually refused for the year of at least 2024 a quitclaim deed. My client has repeatedly made requests for that, and I do have correspondence, email correspondence to her dated May 24th, 1:33 p.m. Correspondence between the parties that would specify that Ms. Copernall, again, as of that date and continues to now, to refuse to sign a quitclaim deed to remove her interest for payment. I wish to call my client to verify information at your leisure.
All right, just 1 minute, Mr. Thompson.
Well, I mean, my client has refused to sign the without getting, she's up under judgment, $11,000 on mortgage. And I think the one correspondence I sent to Mr. Leonardson essentially said that she would file the order once those conditions are met, and those were not met during the period of the order. We're not past the period of the order. Hearing today for the first time finance. Then I see $11,000. I don't keep putting this off. My client's been out of the house since before we filed the suit. She's made several of the mortgage payments during the case, including a few meeting most recently. She would like to be done with this. What we're hearing today is what she would longer it will be done. And I'm not in a position to evaluate that, Your Honor, but it is beyond that.
All right, We've had a number of hearings in this case. I've kind of tried to figure out a way where the parties could come to some kind of agreement to get this taken care of. It hasn't happened. The court has to fall back on the original judgment in this case, which was entered back on April 29th, 2024. And it provides for two options for the disposition here. Number one, defendant will tender to plaintiff $11,000 and remove plaintiff from the mortgage on or before October 4th, 2024. Mr. Leonardson, I can accept, and I don't think anybody's doubting that your client has the $11,000 and is prepared to pay that to Mr. Thompson's client. But so far the question has been, what about removal from the mortgage? And you've indicated that your client's willing to indemnify or take other actions to relieve Mr. Thompson's client from liability under the mortgage. Would, in my view, when I've reviewed your filings, none of those are the same as removing her from the mortgage and refinancing it in her own name, which I think is what the judgment contemplates. And that hasn't happened as of October 24th or October 4th, 2024. So the only other option under the judgment then is for the property to be listed for sale and the proceeds divided equally. And so in my view, that's what's left. That's what parties are left with, absent some agreement outside of the judgment, which there hasn't been. So the court is going to grant plaintiff's motion to enforce paragraph 2 of the judgment. Mr. Thompson, I reviewed your exhibit B. I think it's a reasonable way of going forward in terms of listing the property for sale. So court will order that it proceed on those terms. Mr. Thompson can provide an order under the 7-day rule for the court, reflecting the ruling for today. The court will sign that. Obviously, Mr. Leonardson, you and Mr. Thompson are free to continue to discuss other options outside of that, but at this point, there needs to be some finality to this, and nothing that you're raising, Mr. Leonardson, is really different than anything that's been raised before. So that's a ruling of the court. Mr. Leonardson, again,
Your Honor, my request for that is the only reason it hasn't closed is that by the actions or the non-actions of the plaintiff in this situation. My client has been willing to close for the most of the entire year of 2024. There's been continual rejection of closing without her signing off, and she refused to do that. And I have documentation that shows that she has refused that. It's been at her actions that it hasn't been resolved, not my client. And I don't believe it is appropriate to be penalizing my client for the inaction or the non-action of the plaintiff in this action, in this transaction. She has
so Mr. Leonardson, I'm sorry, you're making the same arguments that you've made in the past. I just disagree with you from a legal standpoint. Your client was required to refinance the property in her own name and have Ms. Coppernall's name removed from the mortgage. And what you've been proposing in our various hearings is that there be an indemnification or something outside of just a straight up refinance so that there is no longer a mortgage with Ms. Coppernall's name on it. And so Ms. Coppernall has refused to sign a quitclaim deed or accept the money because she's not getting what she was supposed to get, which is a refinance and her name off of the mortgage. So she's no longer subject to the debt. No, indemnification doesn't do it. She could still be sued, and then she's got to rely on Ms. Patricino to defend her interest and indemnify her if there's a judgment against her. And that's not the same as refinancing the mortgage and having Ms. Coppernall's name off of it. So what you're telling me, in my view, is not correct. It's the actions of your client and that Ms. Coppernall has properly, in my view, refused to provide a quitclaim deed because she hasn't gotten, in terms of removal from the mortgage, what the judgment entitles her to. So I appreciate your position. You've made it clear for the record. I just disagree. And the ruling of the court is what it is. And that's all I have for today. I'm going to ask all parties to disconnect this time.
Thank you, Your Honor.
Your Honor, for some broadcasting.
Ma'am, are you Suzanne Stewart? Ma'am, is your name Suzanne Stewart?
Yeah, Dave filed that motion, but there was like no notice of hearing, it's just a letter, so was that like?
Ma'am, are you able to hear me?
Yes, I can hear you now.
Okay, great. Is your name Suzanne Stewart?
Yes, it is.
Okay. All right. I'm just waiting for Mr. Stewart to connect. Have you had any contact with him recently?
Yes, I just sent him the information, so I thought he was going to join.
Okay. All right, well, I'm going to go forward today. He hasn't connected. The hearing was set for 1:45 and I have another hearing scheduled for 2 o'clock, so I can't wait much longer. So I'm going to go on the record in your matter. This is Stewart versus Stewart, case number 2411745. The record should reflect that Ms. Stewart is present by Zoom video. According to Ms. Stewart, Mr. Stewart is aware and has the information. He may be having some technical difficulties, I'm not sure, but he hasn't connected. And again, this hearing was set for 1:45 and it's now 1:52. Ms. Stewart, I do want to ask you a couple questions. This is a preliminary hearing in this divorce matter. At this hearing, I tried to determine whether or not the parties have been able to reach any agreements about how to divide up any assets or debts, or whether the case needs to go to mediation for the court, or that decisions need to be made by the court to divide things up. Can you tell me whether or not you and Mr. Stewart have been able to reach any kind of agreements?
I'm sorry, quick question. Is his meeting ID the same as mine?
It should be, yes.
Okay, he just said he wasn't able to get in, but that's okay, right?
Well, like I said, I kind of need to go forward. I'm not going to make any decisions about anything today, so I'm just trying to get a feeling for where you guys are at, whether or not this is something that the court needs to schedule for further hearings, or whether you've been able to reach agreements about how to divide things up.
Okay, we don't really have a lot to divide up. Our agreement has been that he's going to keep what he had before we got married, and I would keep what I had before we got married. And so it's very civil. It's just go on as we were before.
All right. What I'm going to do is set this for another hearing date. I'm going to ask you to there's one final form that you need to have, and you may have already got this form if you printed off your complaint or how did you get your documents to file for divorce in this case?
I had an attorney help me. He did all the paperwork, and then I just filed it.
Okay. So there's one final document. It's called a judgment of divorce. And that's the form that finalizes the divorce. So I need you to get a copy of that form, either take care of that yourself or have the attorney help you with that. And I'm going to need you to file that with the clerk's office here in Grayling prior to that next hearing date. If it's correct that you guys have reached agreements, we can finalize the divorce at that time. And if not, then I can hear from Mr. Stewart and we can decide, kind of where we need to go from there. But that'll give us an opportunity to finalize things at that time, okay?
Okay, so I need to go online, get a judgment of divorce, fill it out, file it with the clerk's office, and in the meantime, I'll get something in the mail to give me the next date.
That's exactly right. Yep.
Okay.
Do you have any other questions?
I don't think so. You had said I just need to file that judgment of divorce prior to that hearing, and that's the only stipulation?
That's correct.
Okay.
All right. You'll get notice of the date and time of that hearing in the mail, as will Mr. Stewart, and we'll go forward at that time. You're free to disconnect.
Okay. Thanks for your help.
Thank you. We're on the record here today, ladies and gentlemen. My name is Judge George Mertz, and you're here today. Ms. Mosier, are these failure to?
You have
appear
two
at trial?
failure to appear, one for April, one for May, and the other one is your show causes. You have nobody present for the questionnaire, the one, which is a 3-page one.
Okay,
So you have, we received 3 of them today, and then so that takes your list down to 50 of them that are not present
okay,
or did not return your questionnaires.
okay. So everybody that's here is for not appearing for it.
Correct, and I did check them on your list. For the ones present, the ones with the X were undeliverable that came back by the post office.
Okay. All right. So ladies and gentlemen, the reason why you're called in today, obviously, is because you failed to appear for jury duty for a trial when you were summoned to do that. So what I'm going to do today, number one, is just make sure that you understand how important it is for you to appear for jury duty. It's not something that's optional, I guess. It's jury duty because it is a duty. As citizens, we have very few ways that we're required to interact as citizens. One of those ways that we're required to act is to appear for jury duty and to serve as jurors when required. It's a very important part of this court. Everyone has a right to a jury trial if they're being charged with a crime. And so obviously it's very important that we have jurors who will serve. So to protect that right that we all have. In civil cases, if you have a dispute, somebody hasn't paid you money, or you're having a dispute with the neighbor, the way that we resolve those is through jury trials. And so it's important that you appear for those types of cases as well. So it's such an important duty that if you fail to appear, the court can, number one, make you come in like you are today. But more importantly, the court can impose penalties. The court can fine you or put you in jail even. That's obviously not something that I ever want to do as a judge, but that's how important it is that the court has the power to do that if you fail to appear for jury duty. So I'm not going to fine anybody today. I think just, the inconvenience of having to come into court today is a penalty enough at this stage. But I do want you all to understand how important it is that when you receive that summons, either appear for jury duty or call the clerk's office. They're very accommodating. If you have issues with health or travel or something else that you can't appear for jury duty, they can excuse you ahead of time so that you don't have to come in today. The worst thing you can do is just not show up. So does any of you have any questions about any of that? No? Well, thank you for being here today. I look forward to seeing you all here at the next trial that you're summoned for jury duty. And you're all free to go. Thank you. Yes, sir.
We cannot opt out. I'm 84 years old.
You can, absolutely. You just need to let the clerk know.
Let who know?
The clerk's office know.
I did that.
He called after the summons was issued and was instructed he needed to be here today because of the show cause.
Yeah.
And then we can opt him out on his questionnaire when he gets another summons.
So that's taken care of now.
Correct.
Okay. So now we know about it. We didn't know about it before, which is why you're here today. So
Okay.
that's taken care of. Sir, did you have a question?
Is there any way to make up for this, maybe volunteer or something for a jury, or is it always just randomly?
No,
I mean, I missed mine. I just totally spaced it out. I called the clerk the next day and said, hey, look, my wife said my name was called and I wasn't here, and I called her the next day, but I understand the importance of it. I volunteered by it.
I appreciate that very much. You can't volunteer, it's random. The good news is we're a small community, so your name will pop up, I'm sure, again. So thank you. So appreciate that. Yes, sir.
So there was, I believe, multiple dates on the paper that you got. You have to appear for all of those dates, or?
Yes.
Okay. So that's why I was misunderstood. I thought I just had to pick a date and come in.
Yes. Okay. Thank you. You're all free to go. With regard to the other ones that did not, so they didn't respond and didn't do a questionnaire. So that's
The
a
other
lot.
judges signed a personal service. And Stearns has been on it. We've had, actually, your list is probably the smallest out of the show causes that we've sent over to the sheriff's department.
Okay.
So.
Well, let's do that then,
Okay.
because they need to get done. So the court will order that, the individuals that did not appear today, that they be personally served, with a notice to appear, and we'll reset those.
And that's for all three of the questionnaires and the failure to appear for jury duty?
Yes.
Okay. Right.
Okay.
Stearns is gonna say, is this all?
All right. Thank you for your.
So Jason Thompson just called and he says they have a proposed judgment on that Copper case if you were still here.
Yep.
Do you want me to text them and say to get back on Zoom? Or,
Well, I don't want to go back to the record.
okay, let me call him right quick.
He's got something in paper that he just wants to send over for me to sign.
Okay, I'll see what he's
But
got.
Tell him I can't go back on the record today.
Okay.
Morning. Yeah. You may, like I said, you may have to go upstairs.
All right, let's see, Mr. Schumacher, are you able to hear me okay?
I hear you fine, Judge.
You're upside
Right.
down though.
Yeah, you're kind of sideways. That's all right. Mr. Blumberg, you're able to hear me okay, yes?
Yep. Yes, sir.
Okay. We'll go on the record. This is Wilson versus Wilson, case number 21-10869. The record should reflect that both counsel are present by Zoom video today. I have this set for continuation of a hearing, and in my review of the file, the last time we were on the record in this case was last December, so almost a year ago.
Right.
So I guess I'd just like to start out today with counsel just maybe giving me a little bit of a update as to what's changed, if anything, where we're at, and kind of what we need to do going forward today. So Mr. Schumacher, let's see, you're representing the plaintiff, and I believe it was originally your motion. Can you kind of tell me from your standpoint where we're at?
Yes. Yeah, Mr. Bloomberg and I have. Can you hear me okay?
Yeah, there's some kind of echo. I don't know. Do you have another connection there in your office?
Well, I
Do you
have
two-
my. Why don't you go upstairs? I'm gonna have my client go to a different room. We might remove the echo.
Yeah, that's the problem when you're signed on with two different devices in the same room. That won't work.
There's always a problem. But Mr. Bloomberg and I had agreed to, as I understand it, Elliot, to we have sent in exhibits A and B from principal, the principal account that's at issue here. And we obtained these exhibits A and B. Elliot's read them, I've read them. And we were going to just stipulate to enter them into the record. And I think Elliot and I can summarize them pretty well, but I first want the court to hear from Elliot.
Judge, it has been a while since we were in there last, and really the issue, as I see it, is that the judgment of divorce provided Mr. Schumacher's client a particular account, and the judgment of divorce stated the value of that account at the time of the judgment. This particular fund, unbeknownst perhaps to anybody that read it, because it's a very long and complicated investment document, by its own nature, changed the interest in this account from a Class C, whatever that meant, to a Class A investment, which the plan on its own did. There was no participation by my client in any way or didn't facilitate that. The plan document required that change to take place. I guess the net effect of that was at the time that the document ultimately changed ownership to Mr. Schumer's client, the value of that account was significantly lower. And my reading of the motion again is that somehow Mr. Schumer's position is that my client somehow effectuated that change intentionally, which damaged his client, meaning she ended up with less money than was originally anticipated. The documents that we finally obtained that have been stipulated to spells out what happens with this account. So that's our position, is that, again, Mr. Schumer and I, neither one of us were trial counsel in this case. And had these things been done properly by the trial attorneys, we wouldn't be here today. But I think what Mr. Schumer is suggesting to the court is that because the account turned out to be less valuable than what was anticipated, my client is responsible for that. Mr. Pete, is that a fair representation of where we are?
That's a fair summation. The documents provide, Judge, if you care to read them, that there's a 30-day notice of the change. In other words, the change in class from Class C to Class A shares. And it's that change in class that precipitated the expenses that were taken out of the fund that my client testified to back in December last year, which was about $6,263.73. The notice should have gone out like March 22nd, because the change occurred on April 22nd. It was a 30-day notice. The mediation was in between those dates. It was on April 12th. And I guess the question we have, of course, is this may well be a mutual mistake on both parties. But at least I think that Mr. Wilson would have had a notice sent to him of the class change. And my client was never provided with such a notice, nor was it given to anyone, as to our knowledge, prior to the mediation, so that if there was a change in value, it could have been discussed at that time. So that's what I think the documents entail, and I believe Elliot would pretty much agree with that. I don't know.
I guess my only comment in regard to that is that even if my client had gotten some notification from the company that there was going to be this change in classification of the investment, that wouldn't have meant anything to him. I mean, it could have been a benefit. I mean, the fact is, the reality, it turned out that the account turned out to be less than what everyone thought it was. There were no misrepresentations at the time the judgment was prepared, because again, Ms. Wilson's attorney is the one that prepared the judgment, and it clearly stated that that was the value of the account at that time. So there wasn't any misrepresentation. There was discovery done. They had that information. I just don't see how this change in classification would have changed anything. Had I been representing Ms. Wilson and I wouldn't have read the entirety of this document and necessarily understood it. The investment by its own terms changed the classification, and it turned out to be worth less than what it was at the time that the judgment was entered. That's really the issue, Judge. Is my client responsible for that? I don't think so.
All right, well, I mean, it may not be a question of your client deliberately concealing or misrepresenting the value of the account. It sounds like if I accept what Mr. Schumacher is saying, which is that the notice of the change in classification of these shares came prior to the mediation, and the change happened after the mediation. So if we accept the proposition that both parties were operating under the assumption that the value as they understood it was correct, and neither party had a reason to suspect, even if they knew about that notice, that it was going to result in that value being diminished by $6,000, then what if we're at a point where, Mr. Blumberg, it's not your client's fault in terms of your client didn't engage in any fraud or something that would excuse the operation of the judgment in that way, but a mutual mistake. What's your position on that? If we take out any fault on your client, but if both parties are operating under the assumption that the value is what it is, when it really wasn't, where does that leave us?
So two things, Judge. First of all, the motion itself in paragraph 9 alleges that he knew about the reduction in value. That was not the case. And nobody knew whether there was going to be a reduction in value or an increase in value. Again, I don't want to point fingers at prior counsel, but the judgment should have stated, if it was the intent of the parties that she was going to receive a $139,000 account, then that should be the sum stated. That provision should have said that, well, let me go back and see exactly what it did say, Judge, because I think it's important. It says, it's further ordered in a judge, defendant is awarded the county financial retirement account. Plaintiff, who is Miss Wilson, is awarded the principal retirement account valued at approximately $132,959 as of April 26, 2021. That's all it says. It does. If the intent was that was the amount she was to receive, then the language should have provided for that. It didn't say that. And again, that provision accurately stated the value of the account at the time of the judgment. So again, I don't think that my client has done anything wrong, and I don't think anybody even thought about the fact that there was going to be a change in classification. Nobody knew it because nobody took the time to read the investment portfolio and the terms of the investment. I mean, it's regrettable. I mean, I'm sorry that Ms. Wilson didn't get the amount that everyone thought she was going to get, but, and again, don't take this the wrong way. I think the fault lies at the people that drafted the document, not the attorneys that have taken this file over.
Well, Your Honor,
what about a mutual? Hold on, Mr. Schumer, I'll hear from you in 1 second. I just want to ask Mr. Blumberg one more question, though. What about the mutual mistake kind of part of this? That
okay, but what's the mistake, Judge? I don't see that where there's a mistake here.
The mistake is that it is what you just said, which is that both parties were operating under assumption that that value was going to be the value, and nobody read the documents. Nobody on either side understood that that was going to change. So, I mean, isn't that a mistake? The parties entered into agreement on an assumption that turned out to be not correct on both sides.
Okay, but let me suggest this to the court. The fact there was no mistake as to the value of the account as of the April 26, 21 date. That was the date that the judgment was entered up. That's not the mistake. This account would have been worth more at the time that the transfer took place. I mean, it was subject to the market activity. So, I mean, again, the proper language would have been subject to gains and losses. That was also not put into that provision. So, if there was a mutual mistake, it was made by the drafter of the document, who was Miss Wilson's attorney. And, you know, again, I'm not pointing fingers. I don't mean to do that, but certainly not. The mistake wasn't Mr. Wilson or Miss Wilson's. It was someone else.
All right. So if that contingency wasn't provided for in the language of that, your argument is that your client shouldn't bear the burden of that mistake. That's on the drafter.
I think that's correct.
Okay. All right, Mr. Schumer.
Well, Your Honor, I think it's Mr. Bloomberg stated it very eloquently that the parties didn't know what was happening, and that if this is back in 21, the judgment was in 22. This whole change in class occurred after the mediation. Notice went out before the mediation, and neither party could probably be faulted for that. It's just something that happened, and what it did, according to the testimony, was diminish the value based on expenses of transferring it from one class to another, from Class C to Class A, a loss of about $6,200 some dollars, but it wasn't a diminishing market value. My client accepts the fact that if there was any diminished market value on the account, she does have to eat that part. But it's the expenses here that I think are a mutual mistake, and they should be evened out.
All right, your client's raising her hand, Mr. Schumer. I don't know if you want her to speak or not.
Well, I think she testified already, Your Honor, that she had no ownership of this account at all until June of 22, when it was finally transferred to her. She got no mail. She got nothing from principal. It all went to Mr. Wilson. And as a result, she wouldn't have even been able to find out anything. So I don't know what more testimony I can give than that. There's no other information she can really provide, as she didn't have any knowledge, but she can state it again if the court wishes.
No, she just was raising her hand, so I didn't know if you saw that.
I
So-
didn't see it. That's nice to see, Your Honor. Thank you. She's in a different room, so.
All right. So I don't know if she wants to make some kind of comment or not. Do you want to talk to her before she makes any statements on the record?
Yeah, if we could just pause for a minute, maybe she could come down, we could talk about it.
Yeah.
Maybe.
Ma'am, I'm gonna have you leave. Ma'am, please leave that device where you're at. Don't take it with you, because otherwise.
Sorry, I didn't know.
Right, she won't.
Be the problem we had before.
Just come down here.
There you go.
We're on different floors so that it might be better reception.
Yeah, that's great. Thank you.
Let me go out in the other room with her and then.
Okay.
We're back, Your Honor.
Okay, thank you. Was there anything you wanted to add, Mr. Schumer, after speaking with your client?
No, there's nothing further, Your Honor.
Okay. All right. I think I understand where both counsel are coming from here in terms of your arguments, and with the submission of those additional exhibits. I mean, how do you guys want to proceed today? Is there more evidence that we need to take, or is it just a matter of the court just issuing a ruling based on the testimony that was provided and the additional documents that you've submitted? Mr. Schumer, what are your thoughts on that?
We don't have any other evidence at this time, Your Honor.
Okay, Mr. Blumberg.
Judge, my client was going to testify, but if we can agree that all other provisions in the judgment have been satisfied, then I don't think we need any testimony from him. But if there's still some dispute as to whether something has not been paid, and we believe that it has, then we'll need his testimony. Perhaps counsel can indicate whether there's any other issues.
Well, Your Honor, I think there's several issues. One is there's one alimony payment that was alleged that not to be paid, that my client testified to was $500. There's also a car that my client received. I guess it's not mentioned in the judgment, but she had, it's a marital debt. It's a marital debt. They both signed the debt on the car. They both are on the title of the car. And it says that he would be responsible for all marital debts. And she's been making the payments on this car, and that comes out to a total amount of whatever she testified to, plus the payments to date and the value of the car at this point. And also, there was this check for, I think, $2,800 from Liberty Mutual that somehow got cashed without her knowledge, and she believed that that was a return of the insurance proceeds, part of which were paid, while in fact all of which I think were paid, while she hadn't even transferred over the interest to the real estate to Mr. Wilson. And so there are those issues.
Okay.
At least those.
Judge, we have physical evidence of the payment of that spousal support payment. We have a copy of the check and her endorsement of the check. So again, if it's necessary for Mr. Wilson to testify to that, he's here to do that. The issue about the car, again, I hate pointing fingers at prior counsel, but the judgment doesn't provide the award of these vehicles to either party. The vehicle that Miss Wilson continues to drive was certainly a marital asset. The judgment didn't award that to her. She's got it, and she's been making the payments on it since the judgment was entered. Our position is that by her making those payments, she's now stopped from taking the position that she shouldn't have to make those payments. If the court finds that the vehicle is hers, well, the court has never made that finding because the car was never awarded to anybody. Again, this is poor draftsmanship. This is just another issue created by the judgment not properly addressing all of the issues in this case. You know, my client's not prepared to reimburse her for every payment that she's made on a vehicle that he doesn't have access to. If it's a marital asset and it was not awarded to her, then he's entitled to drive it as well. That's not a real practical way to resolve this matter, though. Our position is she's got the benefit of the vehicle. She should be responsible for it as she has been from day one. And the last issue is, as I understand it now, is this refund from an insurance policy on a house that she no longer has an interest in. She had left the house and been gone for a year before the divorce was final. There was a change in insurance on the home. There was a refund. My client cashed it, and you know, if the court finds that she's entitled to some portion of that, I guess we can live with that. But I mean, that's the last issue as I understand it.
Okay. All right. I mean, I'm willing to accept your arguments, Mr. Blumberg. I guess the question is, you know, and I just glanced at the transcript. It looks like your client never got a chance to testify. I mean, if you just want to rely on your argument, that's fine. I guess I'm just curious whether we need to take testimony today. That's kind of, that ball's in your court, kind of, I guess, is how you want to proceed.
Well, I mean, Mr. Schumacher can acknowledge, and again, I've got a copy of the June 15th, 2021 spousal support payment for $500. I can put it up to the screen, and clearly that's his client's endorsement of the check. I'm happy to do that, or my client can testify, but I don't even know how that would work. But
well, the payment was for August that he missed. And Judge, if I may just respond, hopefully, you know, the judgment provided that he would take over all the marital debts. This is a marital debt he would indemnify my client. And the court may or not be aware, but I think it's in the transcript that he owned and still has a 2006 or had at the time we had the hearing, a Honda Pilot, a Chrysler Sebring 2009, a plow truck, a tractor, and a motorcycle, all of which had no debt, and they're not referred to in the judgment either. So, and I guess in a sense, you could say this judgment didn't provide for anything except it did provide that Mr. Wilson would pay the marital debts, and this is a marital debt.
Judge, I'm sorry, Pete, I didn't mean to interrupt.
That's all right.
There's no disputes that the loan was in both of their names, but again, because the judgment is silent as to the ownership of those assets, I don't know that it would be equitable for the court to simply say, well, he gets all the debt and she gets to keep the vehicle that was never awarded to her.
But he gets to keep all the other vehicles he has, so I don't think that's.
I don't disagree that this is the problem of the draftsmanship of this document. Where does that put it?
So, I mean, does she now have a claim to 50% of all the vehicles that he got because he wasn't awarded those specifically either? I mean, that's, you know.
I don't
know. I mean, we can open this up. That's another option, Your Honor, as far as I'm concerned. It could open up the whole file and we'd have to thrash it out. But, you know, what we're asking for here is that he reimburse for the payments, the value of the vehicle, the debt of it, and she'd be able to have that vehicle. And if necessary, they'd sign over titles, her to the 4 or 5 different vehicles that he has and he to hers.
All right, well, I mean, we can all go back and forth for hours, just kind of hashing this out and discussing it and making arguments and counter arguments. The purpose of today's hearing was the continuation of the evidentiary portion. So I guess I'd like to get back to kind of, I think we've identified the issues. I'm satisfied that I understand the arguments that each side's making. And it doesn't sound like there's going to be agreement on any of these issues. So again, I'm back to the point of how much more evidence do we need to take so that I can make a decision. Mr. Schumar's client had a chance to testify. So again, I guess, Mr. Blumberg, I'm throwing the ball back into your court as to whether or not we're going to take testimony further or whether the court's going to make decisions on each of these issues based on the record that it currently has before it.
Judge, I think I can make an offer of proof on some of these issues. Mr. Wilson will testify that all of the spousal support payments, including the August payment of well, I don't even know what year it was. All of the spousal support payments have been made. Yeah, in 2021. And now they're being paid through the front of the court, as I understand. Now you're making them still directly? Yeah. Okay.
Yeah, they're supposed to be made electronically through the front of the court. He hasn't done that.
I mean, okay. I mean, I guess that's the first I was made aware. But is that the only payment that's at issue? Is the August 2021 payment?
I think it's August 22 payment, $500.
Okay. So do you have
that? I wrote it on the check special payment because I went back through, one was missing. And I reimbursed the one that was missing.
Okay, so my client is saying that that payment that I referenced was the makeup payment for that 1 month.
Okay, I don't know. I think it might be easier just to swear him in and take some testimony from him on that.
I'm sorry, I didn't mean to interrupt. Yeah, he's right here.
Okay.
I have at 3:30 about a 2-minute hearing with Judge Hunter. Can I just duck out and take care of that at 3:30? kind of notified your staff what was happening?
Yes, they let me know about that and we can certainly do that.
Okay. Okay, well, if you don't mind, I'll have him sworn in.
Yep, perfect. Mr. Wilson, are you able to hear me?
Yes.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Go ahead, Mr. Blumberg. And let's just start with the alimony issue and let's see where we go from there.
Okay, so for the record, Brad, can you state your full name?
Bradley Alex Wilson.
And you were married to Kristen Lorraine Wilson, is that correct?
Correct.
All right. And you understood that you agreed to a consent judgment of divorce back in April of 2022, is that correct?
Correct.
And in that judgment, there was a provision regarding the payment of spousal support, is that your understanding?
Yes.
And did that require you to make monthly payments to Miss Wilson?
Yes.
And what was the amount of those payments you were required to make?
$500 a month.
And was that for what, 72 months? Was that correct?
5 years, yeah.
Okay. And have you made those payments to her?
Yes, sir.
Now, did there come a time in 2021 when there was a payment alleged not to have been made?
Yes.
Had you made August's payment as it was required?
Well, it was alleged that I was missing one, which when I went to the bank and went through the records, I was missing one and I made that payment.
Okay, and so
Extra on top of the regular normal.
the extra payment that you made, was that a check written to Kristen Wilson?
Yes.
And did she receive that check to your knowledge?
Yes.
And do you remember the month in which you made that check payment?
I actually, the one that was missing was made, it was never cashed, so I don't know if it got lost in the mail or she lost it or didn't cash it. I never received it back and they couldn't find it, so I reissued that payment.
Okay, so as far as you know, all of the payments that you've been required to make have been made?
Yes.
Okay. Council had raised an issue that apparently these payments were supposed to be electronically made to her. You've not been doing that?
I mean, yeah, I go on to my bank account and I do it electronically every month. It goes right to her account.
Okay, so you're not writing checks to her anymore? No. Okay, so you aren't paying her electronically then?
Yes.
Okay, and
But
again,
not through the front of the court.
okay, I understand. As far as you know, are all other payments current? Have you paid them? Okay. So let's talk about all other provisions of the property settlement. You were required to pay her $15,000 for her share of the equity in the home.
Yeah.
Did you do that?
Yes.
Okay. It also says that you were awarded all marital property still situated at the marital home at the time this order is entered. What vehicles did you have at the time that the judgment was entered?
The Honda Pilot. There was an old plow truck and.
Can you speak a little bit louder so everybody can hear you?
The Honda Pilot, there was an old plow truck and the old Chrysler Sebring.
Okay. Were all of those vehicles paid for?
Yes.
Okay. What vehicle was your wife driving at the time?
She got that Toyota.
Okay, what do you remember the year or make?
Toyota, I think Corolla. I'm not sure what the year was on it.
Okay. And did that have a loan on it?
Yes.
And were both you and she on that loan obligation?
Yeah.
Okay. Now, the judgment of divorce that Miss Wilson's attorney prepared didn't address an award of any of those vehicles, did it? To your knowledge?
No.
Okay. So the vehicles that were at your home at the time of the judgment, you were awarded those per the judgment of divorce?
Yeah, I believe so.
Well, I mean, let's look at it again. It says the defendant is awarded all marital property still situated at the marital home at the time the order is entered. Those vehicles were at the marital home?
Yes.
Okay.
Not the Toyota.
Okay. So, but the Toyota was in her possession?
Correct.
Was it your understanding that she was going to be awarded that vehicle?
I mean, yeah, I assume we had an agreement that she was gonna keep that vehicle and that she was gonna pay for it.
Okay, but certainly you would acknowledge that the judgment doesn't address who was going to pay for it.
No,
The judgment does say that you're to assume all marital debts. Did you believe that by assuming all marital debts, you were gonna have to pay for a vehicle that she was receiving?
I did not assume that.
We-
No.
I think the judgment speaks for itself.
Well, I'm just asking the witness of what his understanding was.
My understanding
Hey,
was.
hold on. Can I go ahead, Judge, or?
Yeah, I mean, Mr. Schumer, I agree with you that the judgment speaks to it for itself, and it's not entirely relevant to me that what Mr. Wilson's opinion of it was. I mean, the court's gonna ultimately have to decide what that language means. So whether sitting here today, he thinks it didn't mean that. Again, it's just not gonna be, it's not gonna have a whole lot of relevance to the court in terms of what that language means, but.
Okay, I'll move on then.
right.
So Mr. Wilson, you were divorced in April of 2022. Had your ex-wife at any time between the entry of the judgment and motion filed by Mr. Schumer, did she ever make demand of you to make those payments?
No.
What? You need to speak up.
Which payments?
Which
car
payments
on the,
to Mr. Elliott, Mr. Bloomberg?
I'm talking about the car payments on the Toyota.
Okay, thank you.
Okay, so at no time between April 2022 and the filing of Mr. Schumer's motion to enforce the judgment, she never asked you to make those payments? Did she ever ask you for reimbursement on those payments?
No.
Okay, based on her conduct, that is not requesting repayment and not demanding that you continue to make the payments, did you believe that she assumed that obligation?
Yes.
Same objection, Your Honor.
To me, that's a completely different question, so I'll allow that one. I think that those facts do have some relevance.
Okay, so let's talk briefly about this refund from the insurance company. Okay, was that the homeowner's policy that you had on the home?
Correct.
Okay, and so at some point, did you cancel that policy?
Yes, I switched from one company to another because the rates were getting so high.
Okay, and at the time that you switched companies, you switched the policies, had Mrs. Wilson moved out of the home?
Oh, yeah, she's been there for over a year.
Okay, and so when you canceled that policy, you received a refund check of some kind?
Correct.
Do you have some recollection as to the amount?
Just 3,000 or just under that, I believe.
Okay, and was the check issued in both your names?
Yes,
Okay. You cashed that check, did you not?
I did.
Okay. Was Miss Wilson aware of the fact that there had been a refund?
No,
Okay. You know how, when and how she found out?
no.
Okay, and during that year period when she was absent from the house, did you make all the mortgage payments?
I did.
Okay, did that have some bearing in your mind as to whether she was entitled to some portion of that refund?
Yeah.
Okay. Let me see if there are any other issues we still need to talk about. Is it your position that you have complied fully with all other provisions of this judgment of divorce?
Yes.
Judge, I guess I don't have any other questions at this time.
Okay, all right, thank you. Mr. Schumer?
Your Honor, thank you. I would like to, as to the alimony payment, I would like to have the exhibit sent to me dollars out. But I would like to ask Mr. Wilson a couple of questions. As to the car, your name was on the loan, is that correct?
Yes.
and you were on the title, is that correct?
Correct.
Have you been removed from the loan or the title?
No, but she did have me sign off
I
on.
only if you yes or no question. Thank you. Did you have a you said you owned a 2000, let's see here, Honda Pilot,
Correct.
2006 Honda Pilot, is that correct?
That's correct.
And you owned a Chrysler Sebring, is that correct? 2009?
Yeah.
Can you speak up?
Yeah.
All right. Did you own a tractor?
A lawn tractor?
A
Yes.
tractor like you plow snow with or anything like that, you know, used for the lawn.
Yeah, just a regular lawn tractor. Cutting grass.
Okay, and did you own a motorcycle?
Yes.
Did you own a motorcycle?
Yes.
Did you own a truck?
A old plow truck, yes.
Oh, so now the judgment says, as I read it, and this is something that you signed, I believe you testified to, and that is that you're awarded all marital property still situated in the marital home. It doesn't say around the marital home, does it?
I guess not.
All right. And in fact, you paid $5,000 to Miss Wilson, didn't you, for the personal property inside the marital home? Is that correct?
I believe so, yeah.
All right. Now, let's go back to the insurance company check. Do you have a copy of that check?
No.
We don't have a copy, and we don't, you know, apparently you both owned the home for a while, is that correct?
Correct.
And that you at that time were going to be awarded at the mediation the marital home, is that also correct?
Correct.
And the actual transfer of the marital home was in 2022, is that correct, by quitclaim deed?
Yes.
And you don't know, do you know for sure when what period of time the insurance check covered?
You understand?
In other words, what was it for? Was it for reimbursement of overpayments on the insurance?
No, so the insurance and the taxes are all included in my house payment, the equity fund. And like I had stated earlier, the insurance was getting too high, so I changed insurance companies to keep my payment down. And when I canceled, this was the refund check. But at that time, she'd already been gone like a year and a half, so she contributed zero to that.
But what period of time was the refund check covering? That's what I'm asking you.
Well, I mean, they take it out every 6 months, so you pay it every the bank pays it every 6 months. I pay it every month in my mortgage payment.
That's not what he's asking you. If you don't mind, can I just try to clarify for him, as I understood your question? The policy insurance that was ultimately canceled, what period of time did that cover, the policy?
Oh, that insurance company, it probably been at least 5 years. I can't answer to exact amount, but we had been with that insurance company for a long time.
Okay, but you're still not understanding. was it for a year, that policy? That was in effect?
I mean, I guess, I don't know.
Okay, if you don't
Like I
know.
said, we've had that company for a lot of years. But you know how insurance companies just keep raising the rates and.
No, I understand. Sorry, I can't help you anymore with that question.
All right, Mr. Schumacher, if you want to continue.
Well, all right, well, I guess we'll leave it up to the court, but the point being is that part of that check could have covered some of the time that your wife said she had not deeded it to you until June of 22 or May of 22.
No, she'd been gone at least 18 months at that.
I'm asking when she deeded it to you.
I don't recall when I refinanced.
Well, let's go back on that. You were ordered to, by the judgment of divorce, as I read it, you were ordered to, refinance the home. Is that correct?
Correct.
And in fact, it looks like the judgment provides that you should do all these financial obligations within 90 days. When did you refinance the marital home? When did you finally apply for it?
I don't recall how long after it was.
All right. Could it have been in the spring of 22?
Yeah, probably.
All right. So that's about 10 months after the judgment was entered. Was it? I mean, spring of 23. I'm sorry.
Well,
right. Yeah. I can't get in my. But it was about 10 months after the judgment was entered. Is that correct?
I guess I don't recall, but okay.
All right. So in other words, there was a period of time where Miss Wilson testified that she suffered, a loss, that she couldn't get any credit to get her vehicle, the vehicle we're talking about, refinanced or anything. And so she was in a financial jam and so on and so forth as a result. And this says that you would indemnify her in the judgment for any losses or harm she was suffered. Is that correct? Did you read that correctly in the judgment?
I don't believe there was a 90-day period that I had to get that done in. But I do remember her not wanting to sign the quitclaim deed and delaying that process.
Yes, but that happened after you finally had secured refinancing. Is that correct?
What happened after that?
The quitclaim deed was being presented.
Yeah, that was delayed. The whole process was delayed because she wouldn't sign it.
So you're saying that she wouldn't sign a quitclaim deed way back when? Is that right?
Yes, when I started the refinance process.
Okay, but when did you start to refinance? Testified it was about 10 months after the judgment.
I guess. I mean, I don't recall, but yes, it was a while after the judgment.
All right. Okay. So as I understand it, you have not made any payments toward the vehicle that your ex-wife has at this time, correct?
Correct.
All right. Well, I think that's it for the questions at the moment, Your Honor. Can I take a break for a minute?
Let me just see if Mr. Blumberg has any additional questions.
I may have some. I just want to talk to my client, but go ahead.
Oh, okay. You want to take a break to confer with your client to make sure you're done with your questions? Is that it?
That's asking, yeah.
Oh, okay. Yeah. Go ahead and do that. If everybody can just stay on the line.
All right. Thank you. give me a couple minutes, maybe it's time for Mr. Bloomberg to take care of his short hearing. I don't know.
Yeah, it's at 3:30 though. I'm not sure I can get into it this time.
Okay. All right, just a minute.
Shamar, did you have any other questions?
I do, Your Honor. Mr. Wilson, what period, what day are you saying that you made a double payment for the?
Yeah. So the specific check that I'm talking about is, it's number 104. And it says June spousal support in the, where you write the information on. So this is the one that she claimed I missed, which I issued it, but it never got to her. She did not cash that check and I reissued it. And it's
I asked you
of
the check.
I'm sorry, what'd you say?
6 when?
6/15 of 21.
What was the date of that check? June of 21?
Yes, 6/15.
Okay. Well, the check in question is August of 2022.
Well,
So
go back and look. I mean, I don't.
I guess I'd like to see your records and maybe your attorney and I can resolve this issue for the $500.
Okay, I'm sure we can do that.
Okay, the other questions I have is you owned totally the principal account and the countrywide financial account at the time of your divorce. Is that correct?
Yes, they were both my name, yeah.
All right. And your wife did not have any access to those accounts whatsoever, did she?
Not that I'm aware of.
All right. So if there was mail or anything sent, it would have gone to you. It would not have gone to her. Is that correct?
Correct.
And do you recall back in March of 2021 getting a letter from principal?
No, I don't.
That talked about changing the class of shares from Class C to Class A?
No, I don't recall receiving anything from them on that. Although I will say, and I don't know if it's relevant or not, that.
Well, I'm asking you if you recall if you got a check, or a letter to that effect. Did you get a letter?
No, sir, I don't recall.
Well, the exhibit says that a letter was sent out around the 22nd of March, notifying everybody who had Class C shares that they would be turning over in 30 days on April 22nd to Class A shares. Do you remember anything about that?
I do not. I mean,
you answered it.
I don't remember, no.
All right, now with regard to this insurance check, let me ask you this. When did you cash that check? Do you remember?
I think it was like spring or late winter of whatever year it was. It was probably in the beginning of the new year. I don't recall.
The beginning of this year or what?
No, I think it was no.
Is it safe to say you don't know?
I don't recall, no.
All right. And at the time that you received the check, did you have a joint account with your wife, your ex-wife?
What do you mean a joint account?
Did you have any joint checking accounts or otherwise with Ms. Wilson?
No.
All right. Now, how was the check made out? Was it made out to you and her?
Yes.
And how is it that you cashed? Did you get her permission to cash that check?
No.
Did you sign her name to it?
I didn't have any contact with her at all.
Did you sign her name to the check and cash it?
Yes.
No further questions, Your Honor.
All right, thank you. Mr. Blumberg, any follow-up?
I just want to clarify a couple things. The judgment of divorce that was prepared by Miss Wilson's attorney indicated that she was to receive $15,000 for her equity in the marital home. Did she receive that amount?
Yes,
And did she receive that within the time frame prescribed by the judgment?
yes,
Okay, so the actual refinancing, you say, took some extra time because she would not sign the quitclaim deed?
that's true, yes,
Did that delay the ultimate ability to get her name off the mortgage?
it did.
Okay, do you know of any, did she ever share with you any information, any documentation that suggested she suffered any kind of financial harm as a result in the delay of refinancing?
No,
And again, as to the automobile issue, did you have to sign at some point a title over to her?
yeah, she asked me to do that. She said it was to get my name off the thing,
Off what thing?
off the,
Loan?
yes,
Okay. So you signed the vehicle over to her even though it didn't award her the vehicle in the judgment?
well, yeah, yes,
Okay. And you did that because she said that she was getting the vehicle?
yes.
Did she also tell you she was refinancing the loan to get your name off of it?
I don't recall her saying that, no, but
Then why would you sign the title over to her?
because that's what I assumed she was doing.
Okay, you assumed she was doing it.
Yeah,
Did you, during that same period, did she ever ask you for any of the payments for the vehicle? Never asked for reimbursement?
no,
Isn't it true that over a year went by before she ever asked you to reimburse her for any of those payments?
whenever this came up is when first I've heard of it.
Thank you. I have nothing else, Judge.
All right, Mr. Blumberg, do you need to sign off to go to your other hearing?
I do. Judge, can I make a suggestion? I don't know
Yeah.
if you're going to rule on these issues today or not, but I would certainly like to provide the court with at least a memorandum of law regarding the issue of estoppel as it relates to Miss Wilson's year wait before she ever asked for reimbursement. Or does the court feel that you don't need to even consider that?
Well, I mean, number one, I'm not going to be able to rule on this today. So if the parties want to file, some additional briefs in light of the testimony and argument that was made today, I don't have any objection to that. But either way, I think we're going to need you to come back to this hearing because Mr. Schumar's got an opportunity for recross. Did you have recross, Mr. Schumar?
I do a little bit, Your Honor, and I'd like to talk to my client in light of what was said.
Okay, I mean,
Okay.
my hearing is only going to take a couple of minutes at the most.
Okay, so Mr. Blumberg, why don't you go ahead and sign off? I'm going to put everybody into the Zoom waiting room, and then once you sign back in, we'll resume, okay?
Okay.
Thank you.
All right, so do you mind stepping out just
Nope.
for a second?
Yeah, you got it.
It's just coming.
What was that? Sorry.
Oh, no, I just let Chris know that Elliot was
Okay, looks
I'm
like
back.
we're back. Everybody's reconnected. Mr. Schumacher, you can go ahead and proceed if you have any additional questions.
Just a little bit, Your Honor. Thank you. Mr. Wilson, you did testify that it was sometime after the divorce judgment, possibly the 10 months, where you tried to refinance the house. Is that correct?
Correct.
All right. And before that, was that the first time that you made an effort to refinance the house?
Yes.
All right. I have no other questions, Your Honor.
Okay. All right. Thank you. I don't have any additional questions for Mr. Wilson. I think I've got, enough testimony on the disputed issues. So, I would suggest a 14-day period for each side to submit any written closing arguments that they would want to submit. Mr. Blumberg, is that adequate amount of time for you?
Yes, Judge, I can do that.
Could I have
Schumacher?
21 days, Your Honor? Could we have till like 21 days?
Yeah, any objection, Mr. Blumberg?
No, even better. Thank you.
Okay.
And then
right.
Also, if Mr. Blumberg could get me his copy of whatever alimony payments were paid, we might be able to take that issue off the table.
Okay. Yeah, if you guys are able to resolve that, just put that in your written submission so that I know that that's not an issue that needs to be ruled on by the court. Once I receive those written submissions by the parties, the court will issue a written opinion based on the record before it. Mr. Schumacher, on behalf of plaintiff, anything further that we need to address today?
No, Your Honor. Thank you.
Mr. Blumberg?
No, Judge, thanks. And I appreciate you allowing me to run to the other courtroom.
It's the beauty of video now. You can go back and forth pretty easily.
It's a godsend.
It is.
Okay, thanks, everybody. All parties are free to disconnect at this time.
Thanks.
All right. Thank you, Your Honor.
You want to take that with you?
So I'm going to take the whole thing. That concludes the court.